Welcome to this presentation on the ownership of research data. Basically, lets us consider a couple questions. Who owns our research and who owns our ideas are embedded within this, and there will be an extension of that with the follow-up lecture to this one on intellectual property, the patenting procedure, and a few things like that. And basically, this comes from at least what had originally been Chapter 6 of the Shamu and Resnick textbook that we have used for this course. So the information in here parallels that chapter to some degree. Some of the IP information is in the forthcoming lecture. So I did a little search under this category of research data integrity and management, and found a recent, at least at the time of the recording, publication released by available from National Academic Press, but it was actually sponsored by the National Academy of Sciences and several other similar types of scientific academies that are obviously involved in trying to standardize procedures and processes within the academic research arena. Now remember, what we're dealing with here is the typical type of non-IP type of research. If you're going to be doing intellectual property research, especially anything where you might want to have it get for human use and consumption that would require FDA approval, then you want to go on to get trained in good laboratory practice, good clinical practice, and then possibly good manufacturing practice, or GLP, GCP, and GMP. What we're talking about here is a bit like that, but it doesn't come close. There's a lot more that needs to be done. But anyway, this is still very much the same, ensuring the integrity, accessibility, and stewardship of research data in the digital age. So data is data, but the format of data for GLP and GCP is going to be different than what you might be accustomed to recording for your general research activities under an NSF, NIH grant, or something like that. So I pulled just a bit from the table of contents for this under this chapter called Ensuring the Integrity of Research Data, just to see where the trends are going and the demands placed upon the research professionals and their technical staff persons and trainees as well. So the roles of data producers, providers, and users, the collective scrutiny of research data and results, peer review and other means of ensuring the integrity of data, data integrity in the digital age and the role of data professionals, general principle for ensuring the integrity of research data, obligations of researchers to ensure the integrity of research data, importance of training and producing clear, up-to-date standards for data integrity, a shared responsibility of the research enterprise, and then finally the roles of data professionals, experts in the arena of data collection, recording, and storing and archiving. So it's a very different business to be in the academic and industrial research for that matter. So what are the objectives of our talk? We will consider what research data actually can be defined as, a little bit on integrity and misconduct. Our case studies help us get through that as well. Data sharing, data storage, ownership, access, and retention. So what is data? Products of research that are intended as a basis for reporting of research findings in the context of the academic research, as I had mentioned. So this is not a definition necessarily that you would consider in the sense of reporting as a publication for IP. So the technical data, computer software, laboratory notebooks, field notes, memoranda, and unique university resources fall into this category. The organization and requirements for laboratory notebooks under GLP are very different than what you might be accustomed to. So if you think that you're very good at keeping a laboratory notebook, you might want to check into the GLP style of notebook to see where you would stand if your data was under scrutiny for a GLP type of assessment. So I went looking for a definition as well from the National Institutes of Health and came up with this grants policy statement that defines the data as recorded information regardless of the form or medium on which it may be recorded. And it includes writings, films, sound recordings, pictorial reproductions, drawings, designs, or other graphic representations, procedural manuals, forms, diagrams, workflow charts, equipment descriptions, data files, data processing, or computer programs, the software. So you would need a version of that software that it was originally stored under as raw data if sometime in the future it had to be accessed and there was no computer with that software on it. Statistical records and other research data. This approach frames the definition on how the information is recorded, and I gave you the link to the website where I found this information. So why do we have such a scrutiny over these sets of information? Well, obviously it's related to misconduct, but as I said, the better way to think about it is the integrity of the data, period, and that it is always available to substantiate the findings if they supported your hypothesis, or maybe even if they didn't support your hypothesis. Garbage in, garbage out is the old saying. And of course, when it is with malintent, there's fabrication, making the data, the results, recording or reporting them, falsification, manipulating the research materials, equipment, or processes, or changing or omitting data or results such that the research is not accurately represented in the research record. And plagiarism, which we've had discussions about in this course. So you've seen case studies already of how these three types of misconduct play into our profession of research, and what some of the actions are, what some of the ethical sanctions, and even possibly legal actions if they're quite extreme. So these are the bad things. We don't do things to prevent bad things from happening or to protect ourselves from the harm if we do something bad. But we need to be aware of what would be considered as bad and that actions would be taken. Other reasons for scrutiny: as a result, the integrity of the data must be maintained, and issues of ownership, access, retention should be put into the institution policy, as these data records will be the main source of materials investigation during an allegation investigation of the research misconduct. So I have a 3 or 4 slides here where I'm just going to read to you from them on this topic of ownership. It's rare that you will find yourself in a situation where you will own your research data and results, and possibly even the creative ideas that are embedded within it. Traditionally, scholarly practice at most institutions recognized the investigator as owning the data that resulted from his or her research. That tradition is long gone. With the growth of sponsored programs and the related award requirements, however, institutions are increasingly asserting ownership over data resulting from research. Confusion and potential conflict may result when an institution's intellectual property policy is silent on the issue of data ownership, but claims ownership of inventions that may be embodied in or documented through this data. In general, federal policy and guidance supports institutional claims of data ownership or federally funded research. Under MB Circular A110 of the NIH, the rights to intangible property belong to the institutional grantee. So the institution, not the individual, the PI. The NIH grants policy statements state that grantees own the data generated by or resulting from a grant-supported project. The NSF gives grantees rights to their data as well. While federal sponsors have recognized grantees' ownership rights in the data and research results, they retain a broad right or license to use the research results. On the other hand, some federal and a growing number of private sector contracts, as opposed to grants, now require that sponsors be granted ownership and/or unlimited, sometimes exclusive rights in data as a condition of the award. Research institutions generally refuse to relinquish ownership and rights in data because such limits on ownership or access conflict with the goal of sharing research results to advance the field. At a minimum, most institutions retain rights to use the data for research and education purposes. Some institutions narrowly limit the rights assigned to research sponsors through such mechanisms as the nature of the report to be provided to the sponsor, or as limited to the field of use for the sponsored. Before agreeing to any limits on rights and ownership, the research administrator should discuss the implications with the investigator and consider the impact on the institution's teaching and research missions. In its role as the grantee, the research institution is required to hold little to or own the data through its contractual obligations. Most states impose a similar ownership obligation on their state-assisted universities and research institutions. By tradition and for practical reasons, the creators of the data retain possession of the data on behalf of the institution. So we'll apply a term to that called stewardship as we proceed. As custodians of the data, investigators must be thoughtful about any assignments of copyrights made without consultation with the institution. Investigators should review copyright assignments usually required for the publication of journal articles or books. These assignments generally give the publisher all rights to the article or manuscript, not the data, which will limit the author's ability to use the publication in future works. The author should retain the rights to use the publication for research and educational purposes. Just signed a transfer of copyright agreement for an accepted paper today, and indeed this is stated within the publisher's documentation, recognizing this general need in our society. So one principle is clear: as institutions consider creating a research data policy, a broad, clear definition of data will provide the greatest flexibility for the institution. The policy should acknowledge the broad context of the institution's research program and yet address the specific situations spawned by individual programs and existing sponsor requirements. When an investigator leaves the institution, what happens to the data? So this is what you need to think about if you are a trainee. When you finish your training, we'll read through this, but basically when you leave, you have no rights to bring anything with you. Everything is left behind because it's owned by the institution. The grantee institution is responsible for archiving that data, the original data, and the PI is responsible for the stewardship. There are a variety of circumstances under which active and productive researchers may leave an institution, and trainees. Generally, researchers will believe it is appropriate for them to take all of their research records with them, yet institutions are obligated to assure access to and the retention of data, and possibly to defend the value of associated intellectual property. If the departure is the result of failing tenure or of perceived or real disputes with the institution, investigators are unlikely to take a positive view toward institutional claims to data. The challenges associated with departure of principal investigators represent another clear and perhaps the most compelling justification for institutions to consider the establishment and communication of policy describing rights and obligations of all parties in the management and retention of research data. So now let's transition over to data sharing. We've talked about how institutions need to keep close vested about where the data is and what are their responsibilities and liabilities associated with it, and therefore the oversight that it is secure and accessible. Now let's talk about expectations that we share our data, even though we're good stewards of it. And when do we have limitations on exactly how we can share the data, and what are the requirements for what how we might have to share the data in ways that we would prefer not to. Well, for proprietary information, IP leading to patents and things of this sort, sharing has to be done very carefully. The public disclosure can destroy the potential of the patentability of in what could be considered as an invention. So if you don't know really what is an invention, you should go and look at some patents online in your relative research area. And the United States Trade and Patent Office, USTPO, is a great place to go and to look, search up patents, and just see how they're written, see what's in one, and see what it encompasses. It's actually quite global, and you may find that you've already presented enough of the information that you have to where you have destroyed any chances of ever getting a patent with it. It's very easy to lose grip of that. So there are limits on data sharing, and it is recognized that for commercial purposes, potential economic benefit to the institution and the community, that some information can be withheld, and you may even be asked to sign a non-disclosure agreement. So there are technical obstacles. There's confidentiality. If a colleague shares some information with you, things of this sort. Concerns about qualifications of data requesters, so who's asking for data, and the costs associated with sharing. If you make them available, or if you have to ship something, then who should have to pay? So these are things that need to be worked out. The NIH and NSF require data sharing if the work done or published was funded by these agencies. It's the public tax dollar, and it should be publicly available, is the overarching principle of our society through the regulations of the federal government. Other funding agencies may have similar requirements or the same requirements, and part of the terms and conditions, these requirements would be part of the terms and the conditions under which you would accept the research funding. So if you cash your paycheck, you've accepted the conditions of the source of the funding. So under data storage now, obviously this is not how it should be stored. So there's issues to be considered, those of space, whether it's electronic or physical, retention times, how long. It's a minimum of 3 years. That's a safe bet that I've seen in many places, documents I'm referring to. And it'll depend on the source and the type of data. Now, for good laboratory practice, good clinical practice, things with the FDA, with patents, sometimes these are indefinite. The monitoring, or even like for 20 years, the life of a patent, something like that. So they have to be monitored if people are coming and going to get them. Some places, actually with good laboratory practice at some institutions, they'll have a dispensary where they are picked up in the morning and then returned at night, and they're at the end of the workday, and you quit a little bit early because you have to go there and get your lab book, your lab records inspected before you leave for the day. Everything has to be done properly within the same day that the work was done. The security, just as I was saying there, but regardless, it can't be left out like this, shown here on the upper right. And the responsibility is of the investigator first, and ultimately, of course, the institution. So now let's transition a bit to the ownership of research data. We have just a couple more slides here. If this happened to be in the the slide set that I found and kind of modified as I went through it here. And it was showing this from the research of the University of California. I can assure you that in the United States, any one of the 50 states, the regents for the local universities, the state universities, public supported universities, and any private university you go to, it'll say the notebooks and other original records of research are the property of the university. So you cannot leave the campus with an original record. You're not supposed to take them from the laboratory. All original records are supposed to stay within the confined, secure spaces of the research facilities of the PI. And then there has to be permission to make copies and to remove copies. Say you finish up your doctoral training and you're taking some data with you as you go to a postdoc training to complete that one lingering manuscript for publication. You really need to make official arrangements so that you have copies and not originals, and that you have appropriate permissions. Because once you break one of these rules, these laws, it follows you forever. So the penalties can extend back quite a long period of time. So the ownership policy, then, the policy should address that if you find one for UTSA, you should see that there's a definition of research data, information on ownership and stewardship, acquisition and use, retention, access, transfer, storage. So the challenge for you, if you're training at this institution to become a researcher, and any institution you go to subsequently, is seek out these policies, ask for them, make sure that you understand the policies under which you are working. And certainly you've already accepted money for the tuition of this course, for your initial paychecks on your stipends. So you have agreed to them one way or another. You have signed a contract for your stipend. So become familiar with the conditions under which you are training and how it impacts your work now and into the future. So ownership versus stewardship. The university owns the data. The university doesn't really own your ideas until you put your ideas in some type of documented form that they now can lay claim to. So you need to understand the distinctions between what is a situation where you can have a creative idea, a creative expression that could be patentable, and when you may or may not own it. Basically, if you work for a university, they're going to own it at one time or point or another. You may do all the IP and the patenting and start a business and make millions, and as soon as you're making millions, that's when the university is going to discover you, and they'll send their lawyers after you and see what money they can get out of you. So you need to understand this in great detail if you even ever suspect that you might generate that type of intellectual property. So regardless, you as the investigator will have stewardship. So your PI, your professor, your training professor, has to keep the original data in his or her laboratory. The university maintains rights to access the data at any time and directs the investigator as to retention times of specific types of data. In summary, then, the institutions should address issues of data integrity and management in policy developed by university administrators that take into account historical university position, as well as the context of today's global technological environment. So I hope that this brief talk has helped you gain insight into this very important aspect of your professional career as a research scientist.